All right, before we go on the record, what is this case out of Edwards County? Have you had a chance to review the
Yes,
PSI?
I have completely.
What is the awaiting hearing on that? Is that still a waiting
He has
hearing?
a plea bargain that he'll be entering on January the 8th with 3 years probation.
Okay,
January the 8th, 2024.
okay. And if your client is drug tested today, what are the results going to be
Positive.
for?
Okay.
Okay. All right, court is calling 2022 CR 11790, State of Texas versus Renee Cantu. Can I have parties announced for the record for the state?
Jason Gearhead, Your Honor.
Defense?
Roy Barrera Jr.
Right. And are you Mr. Cantu?
I am, yes, ma'am.
All right, you entered a plea of no contest on October 11th. The state waived count 1. They proceeded on count 2 only. You applied for deferred adjudication. According to the plea bargain agreement, punishment must be assessed at 4 years in the prison, and the state is remaining silent on your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense? Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right. Anything you wish to say on behalf of your client? And I think the first thing that needs to be addressed from the court standpoint is the acknowledgement or guilt or not acknowledgement of guilt that it says in there.
Right.
All right. So yes, the state is silent. So you may begin, counsel.
Regarding his acknowledgement and acceptance of responsibility, he unequivocally accepts responsibility for that behavior that he's performing today. Number one. Number two, he is willing to accept the fact that he has issues regarding drugs and the use of drugs. He has, needless to say, been in denial for most, if not all, of his life, that he does not. The fact of the matter is, Judge, that he lost his father to prison when he was 2 years of age. He's now 32. His father is still in prison to this day. He lost his mother to a drug overdose, and he was raised by CPS. He has never had a psychological evaluation in his life. He has never been on medication for any of the issues that were caused by abandonment and by basically roaming the country.
Mhm.
He wants to change his life. As the pre-sentence investigation said, he is, I think they use the term, he's just about there to accept responsibility and to receive and accept help. If you should place him on probation, Judge, I'm asking that you order a psych eval, because I do believe that my client is suffering from illnesses that have never, ever been treated or been diagnosed.
But you believe he's competent?
Absolutely.
Okay.
No doubt. My client is an intelligent person. For the very, very weak and almost non-existent formal education he's received, I find him to be way beyond his educational years as far as his intellect. So he stands before you asking you to consider his applications, either one, as the court may see fit, but that he brought some documents as proof that he's not a loser, and that he has done things to his credit, which I'll ask him to mention to the court if that's possible.
Yes. And I can tell you this, everybody who appears before me,
Mhm.
and what they've done I never consider anybody a loser or anybody a throwaway. Some people have made bad decisions in their life and there are consequences for that, but I don't see people as losers.
Right.
All right. Yes.
Good afternoon, first of all.
Good afternoon.
So, Your Honor, I had a messed up childhood, period. I was in CPS since I was 9 years old. If you only knew the amount of stuff in CPS that happens.
I do.
So of course I had a totally messed up childhood. I'm not making an excuse for that, but as I grew up, little by little, of course I was crazy. I was stupid doing
Okay,
everything.
and let me stop you for a little bit because I need to swear you in. Can you raise your right hand for me? Do you solemnly swear a firm testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and you can continue.
Okay, so yeah, as I grew up, I was wild. I was stupid, making a lot of crazy decisions. So yes, I did mess up. I still have cases that are pending or whatever.
Mhm.
All that is by one specific officer. It's not like I messed up and messed up and messed up. No, it's all by one specific gentleman. He just put different words. But since then, I used to live with somebody. Now I have my own house. I have a copy of my whole lease. I have all of my check stubs from my employment. I even have business cards now. I'm a certified mortgage inspector.
Okay.
All the bond I paid 14,000 total in bond. Good. I don't owe anything else. I paid pre-trial in full. I actually have a credit on pre-trial. So I'm good now. Like I have everything going for myself now. Back then, of course, I was stupid. I'm like, okay, come on, But dude, now I have everything that I have going. Do you get what I'm saying?
I get what you're saying, but you want to know if I'm catching what you're saying.
Are you catching what I'm saying?
Yes, I am. I caught it.
So I admit I need help. Help, like therapy. Yeah, that's the help I need. I don't need help going to prison.
Nobody
That's-
thinks they need to go to prison, though.
Yes, ma'am. You're right.
Even people who commit murder, they will always say, I don't need to go to prison for murder.
Yeah, but therapy, like I want help me out with my head. You get what I'm saying?
Mhm.
But yeah, that's all I ask. Thank you, by the way. Thank you for everything, every time.
Okay. Any questions?
Yeah.
All right. So you're over 30,
Yes, ma'am. Correct.
32.
32. I'm going to tell you what I would always tell people that I would represent in Child Protective Services, because I know the government is not in the business of raising children. And 9 times out of 10, the government doesn't do well at raising children. Parents are supposed to be raising their children and they're not. But I'm going to tell you this. Every tub got to sit on its own bottom. You know what that means?
Not really.
All right. Let me tell you what that means, because my grandmother would say that to us all the time. This is what it means. At some point, your bad life that your parents gave you or that somebody else gave you, you can no longer blame it on them. At some point, you sit on your own bottom.
Correct.
Imagine yourself a tub. You got to sit on your own bottom. So at some point, the decisions you are making, you can't say, I'm making these decisions because of my childhood,
Correct.
because you are now in your 30s
Yes.
and you know what the law is. You know what you should not be doing.
Yes.
So you're going to have to stop doing that.
Yes, ma'am.
For example, you need to start being negative for all drugs.
Yes.
Unless it's a prescription, you shouldn't be turning up positive for it.
Yes,
If
ma'am.
you do, you're not doing well. You
Yes, ma'am.
understand?
Yes, ma'am.
So you're coming to me, asking me to grant you probation or either deferred adjudication, correct?
Yes, ma'am.
Do you want to go to prison?
No, ma'am.
All right. So if I were to grant you deferred adjudication, you're looking at the full range of prison if you mess up on it.
Correct.
If I were to grant you regular probation, the most I could sentence you to if you were to mess up would be 4 years. So I'm going to give you the treatment that you say you need, but right now I'm going to give you a choice.
Yes,
Here's your choice. I can grant your application for deferred adjudication. The good thing about deferred adjudication is it's not a conviction on your record, but anybody will be able to see that you're on deferred adjudication for this.
Correct.
Now, if I grant that and you are unsuccessful, then you're potentially looking at 20 years in prison.
Correct.
Or you can have a conviction. If I give you a conviction and you mess up on it, the most I could sentence you to would be 4 years in the prison. You're saying yes, so which would you prefer?
The latter, please.
What, the
The
4
second.
years?
Yes, ma'am. That's with the probation.
That's
If
where
I
you have a
mess up.
conviction, and if you mess up, the most you could get is 4 years. But there are issues that come with a conviction, and I'm sure your attorney can tell you that. So you want to talk to him about whether he,
We have already discussed
So-
the difference, and Your Honor, that's why I left it up to you when I said, you know, obviously it's your decision, but in the event that you did not grant deferral, of course, he wanted to ask you for probation. And
oh no, sometimes I give people choices.
as today, his choice would be, and we discussed it, is straight probation.
Okay.
Correct, Your Honor. No.
Will that affect your job? Are you licensed by the state?
Correct, yes.
Well, it might affect your job if you're licensed by the state.
Mhm.
You may need to have deferred.
Well, jobs are so easy to come by now. If you want something, you're gonna get it.
Okay, well, you tell people, jobs are so easy to come by, everybody. So when people come in here saying they can't find employment, they're
That's an
just not
excuse.
looking. That's
Go be a go-getter. That's how I've been. Go get a damn job, period.
okay.
You
Thank
know?
you.
Sorry.
All right. So here's the thing. What I can tell you, because I would have clients that would come to me. I even had somebody who was trying to be a nurse. They had went to nursing school and they came to me after the fact and they say, hey, I have this theft case and they're not giving me my license because of this theft case. Can I get it expunged? Can I get it off? And I had to tell her, I'm sorry, you can't. You'll just have to get some people to write letters for you and maybe nursing will allow you to still have your license. So in the state of Texas and usually in other states as well, anything that requires a license, they run a background check on your criminal history. And if there is criminal history, I'm not saying it's impossible to get your license, but it's extremely difficult. I just went to felony drug court graduation. Someone has long history. They successfully graduated. And guess what? They are now a licensed attorney, but they had to have everything in order and make sure they were on a straight and narrow.
Correct.
So here's your choice. The 4 years, the probation, where the most you can get is 4 years, or either deferred adjudication. Which would you prefer?
I would pick probation, Your Honor.
Okay. All right. The court is going to find you guilty. The court will sentence you to 4 years in the prison, suspended and probated. What are you requesting?
4 years.
All right. Because of his history, I'm going to place him on for 5 years.
Okay.
All right. So 4 years in the prison, suspended and probated for 5 years. If he completes everything, I'll consider early termination.
Are you gonna be here in 2.5 years?
We shall
Good
see.
question, you know, that is.
We shall see. God willing, and the creek don't rise. So whether I'm here or not depends on things that are not in my control. All right. And your attorney knows what I mean.
Hey, question, 2 things. One is the ankle
Oh,
monitor.
excuse me. We're not done here.
Oh, yes, ma'am.
All right. See, that's why you should make sure you're clean and sober. Okay.
Sorry. Yes, ma'am.
All right. So it's a $500 fine that will be probated. Proof of employment within 30 days.
Yes, sir.
There's to be no employment as a home health care provider or with minors. Do you have any children?
No, ma'am, sure don't.
Okay. There's to be regular reporting by Zoom or in person. Regular UAs. If you could do a MIC evaluation. And I will tell you on the TAP evaluation, it doesn't mention what he's positive for today on there. So there probably needs to be an updated TAP for that, or either can I just order what I want to order? All right, so we're going to do intensive outpatient treatment with probation. And I'll do a referral to felony drug court. Felony drug court will be able to help him because they have a dual diagnosis program.
Good.
So they'll be able to help him with any trauma. The only thing There may be a waiting list because they haven't had their graduation yet. So if you want to talk to them and see, they may be able to accept him.
Okay.
But they'll only accept him, one, if he lives in Bear County. If he's not in Bear County, they won't accept him.
Yes, ma'am.
Are you there?
Yes.
All right, so we'll do intensive outpatient treatment with probation, felony drug court. I'm gonna ask for 90 sober meetings in 90 days. They do have those online now,
Nice.
and they also have them throughout the city.
Nice.
And gonna do field visits one time per month until he is in treatment. Probation, is there anything else he needs? Community service hours?
Your Honor, maybe 7 hours.
200 hours community service restitution. If you obtain a higher level education, because I see you have some college or
Yes, ma'am.
some type of licensing,
Correct.
then the court will consider the community service hours satisfied.
Nice. Thank you.
Is there anything else? Probation?
Your Honor, did you said regular UAs?
Yes, regular random UAs.
Nothing else.
All right, and with the UAs, if you wish to do it by a patch, you can do a patch. The patch, they put it on you, and that way you don't have to come down to probation for certain things, and then they will take it off.
Nice.
Everything is very nice with you today. All right, that's so 80s, but okay. Is there anything else that you need from the
That's why
court?
I think he needs a psychological evaluation.
Yeah, okay.
No, ma'am, but as I've said before, side note, I love how you're always kind of like me, like you're just happy, holly jolly.
Yes.
But yeah, that's all I want to say. Thank you.
Well, thank you. I appreciate that. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Correct.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, did anybody want to address the GPS? He says he's on GPS.
Yes, he is, Judge. And he has inspections where?
All over the Bear County, Medina County, Wilson County, like all over. She allowed me.
He makes a very good living, Judge, but this,
Well, I tell you what, this is what I'll do. Since he makes a good living and it seems that he can afford the GPS, we will do GPS tracking only. And once the mental health issues are addressed, and once he's in the intensive outpatient treatment, once he's started that, then the court will consider removal.
And Judge, I don't know for certain, but he has several night mag pending cases that I don't know if that's associated with that GPS.
Okay, all right, so we'll keep the GPS.
your probation officer will put you in all
Okay.
these programs.
Okay, cool beans.
Sorry.
Yes, we're gonna keep the GPS.
Tracking only, Judge?
Yes, can we do tracking, or would you suggest not?
The GPS is through pretrial.
Oh, yes.
Ah,
And it was for this case, the 4200.
Okay.
all right, well, he can afford
Correct.
he said he can afford GPS.
So what will happen is that monitor will be removed and then we'll have to get another monitor.
All right, so you're gonna be on GPS, but once you're in his mental health classes and once he's in intensive outpatient treatment, you can always come back. And if he's doing well on it, I would strongly consider removing it. All right. Is there anything else you need?
Thank you, Your Honor. No, ma'am.
All right, so in this court, communication is key if you want to be successful on probation.
Yes.
If there's an issue, talk to probation. If you feel they're not addressing it, you can come to court.
Okay.
All
Thank
right,
you, Your Honor.
all right, you're welcome.
Morning, Your Honor.
Good morning.
He just did everything the judge asked him to do. The judge says to do about and she would consider modifying GPS. That's all.
All right, sure.
Thank you, Judge.
You're welcome. So there's a request for removal of GPS?
Yes, Your Honor. He has done everything the court asked him to do. And for the record, NIC evaluation, 90-day sober support meetings, FDC referral.
So let me ask you this, is he on tracking or?
Tracking only.
He's
You're
on
tracking,
Yes, ma'am.
tracking only, Judge. And
Okay,
he's been on for how many?
A year?
A year.
Yes, ma'am.
all right, state.
Judge, we're opposed. He is pending several charges that are in the process of being indicted right now.
All right, so we're gonna go on the record.
Okay.
Court is calling 2022 CR 11790, State of Texas versus Renee Cantu. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense,
Lloyd Barrera Jr.
are you Mr. Cantu?
Yes, ma'am. Sure, I'm judge.
All right, so there's a motion to remove GPS. Defense,
Thank you, Judge. Yes, Your Honor, as you may recall, my client was placed on probation by this court not too long ago, and we addressed this issue then. At that time, you informed us that you would reconsider the request that we're making today after he completed everything that's on this list that you gave him or probation gave him. So
yes.
we're here to report that he has successfully completed and complied with every single request made by probation and this court.
You mean pretrial services?
Pretrial, yes,
Okay.
ma'am.
Probation.
And probation as well, Judge, both. All right, that's number one. Number two is,
Wait, just 1 second. Is he currently on probation? I don't think he's on
Yes.
probation.
He's on,
Yes.
Judge.
What is the cause number for that?
It is
2022 CR 11790.
All right, could I have that file, please?
So the conditions for probation that should be.
Yes. He's on 5 years probation, Judge, granted.
All right, oh, just 1 second.
Okay,
I just need that file. I don't have it.
sure.
The partner in the back.
All right, if you guys can have a seat and I'll bring you right back up.
Thank you, Your Honor.
All right, you're welcome. Before CR 4260W and 2024 CR 4259W, State of Texas versus Renee Angel Cantu. Can I have parties announced for the record for the state?
Daniel has part of the state of Texas.
Defense,
Lloyd Barrera Jr.
and are you Mr. Cantu?
Yes, ma'am.
Counsel, in each of these cause numbers, have you received all the discovery and did you review it with your client?
I have, Judge.
Everyone, please make sure you whisper. In each cause number, the court will find that the state is in compliance with discovery. Mr. Cantu, in each cause number, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
I sure did. Yes, ma'am.
And each cause number going to show you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review those documents with your attorney? Did you understand them?
Sure did. Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict?
Yes, Your Honor.
Did you understand you have a right for your attorney to have 10 days to prepare for trial?
Yes, ma'am.
And did you understand you have a right, your attorney has a right for the passage of 2 days after the presentation of the information? Did you understand?
Yes, ma'am, Your Honor.
Did you understand by entering into a plea bargain agreement in each of those cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each cause number, I'm showing you what's entitled information. Do you need some help?
It's for you.
What?
Or it's the notes after.
Oh, you want to say something? Okay.
Yes, ma'am. Sorry about that.
No problem. All right. Did you review the information with your attorney?
Yes, ma'am. Sure did, Your Honor.
Okay. Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented in each cause number? Okay. All right. In each cause number, I'm showing you what's entitled court admonishments and defendants' waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand it?
Yes, ma'am. I did, Your Honor.
And the cause number ending in 4260W, you're charged with possession of a controlled substance, penalty group 1 over 400 grams. Range of punishment for that offense is anywhere from 10 to 99 years or life in prison and up to $10,000 fine. And the cause number ending in 4259W, you're charged with manufacturing delivery of a controlled substance, penalty group 1, 200 grams to 400 grams. The range of punishment is 10 years to 99 years or life in prison and up to $10,000 fine. Did you understand?
Yes, ma'am, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand,
Yes, ma'am, Your Honor.
counsel? Did you understand in each of these cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
I do understand, Your Honor.
Did you understand by entering this plea in each of these cause numbers, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Absolutely.
Do you believe he has a rational as well as a factual understanding of the charges against him?
No doubt in my mind.
Do you believe he's currently competent and was legally sane at the time of the offense?
Totally.
All right, Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
100%.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, I'm showing you what's entitled the plea bargain agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am, Your Honor.
Okay. According to the plea, punishment is to the court and it's an open plea. The state is going to oppose your applications. Each cause number will run concurrently with each other. Is that correct?
Yes.
And those cause numbers are listed in the plea bargain agreement as CM 105822 and CM 105821. Do those numbers correspond with the waiver numbers?
Yes, Judge.
Okay.
In case they match up.
All right, and then in each cause number, the state is taking in consideration CM 104043, NITMAC number 712122, and 712121. Did you understand that to be the plea?
Yes, ma'am, that's correct.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor, but can you off the record for this, can I approach?
Sure. Oh, just 1 second. Can you mute us, please? And defense, if you'll come around. So off the record, the state's attorney has informed me that the intake attorney actually did the plea paperwork. Is that correct, state?
Yes, ma'am.
All right. So did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, sure did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Pardon?
Have there been any such motions?
No, Judge.
All right. Then in cause number 2024 CR 4259W, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And then in cause number 2024 CR 4260W, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State, any evidence?
State offer states one, into evidence of states one and all attachments in both cause numbers,
And announce for the record.
and Neil Cordero for the state of Texas.
All right. Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations in each cause number. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I understand, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. And if you could mute us, please. Each cause number, the court will find there's sufficient evidence to find you guilty. And each cause number, the court will find you guilty. I need a sentencing date, TAP evaluation, and PSI. Then we'll come back on June 11th. Probation, this is a TAP evaluation and a PSI. And then the court will make its decision on your application based upon whatever evidence is presented to me and based upon the TAP and the PSI.
Thank you, Joe.
Judge, may I put something else on the record briefly?
Yes.
It's an open felon in possession of a firearm case, cause number 2024 CR 1090 attributed to this defendant. That case is going to be dismissed as part of this plea bargain agreement, but it's not going to be taken into consideration.
Okay.
As the defendant is just not going to plead true to that. I just wanted to put that on the record. That way, in case, I'm not here to handle the plea or, I just want to make sure that's on the record. That way it gets done.
All right, so it's not a part of the plea bargain agreement, correct?
It is a part of the plea bargain agreement. It's just not getting taken into consideration.
It's being dismissed outright, Judge.
It is being dismissed.
Another
outright.
defendant has been convicted and accepted responsibility for that.
And so it will be dismissed for once this plea is taken.
Is there a reason why it can't be dismissed now?
No reason at all.
I don't understand. If it's not being taken in consideration, then,
I'll go ahead and submit a dismissal for it now.
okay. All right, thank you.
Thank you.
Thank you, Your Honor.
All right, thank you.
Our next issue.
Oh, yeah.
The motion.
Remember, we were here this morning on his asking the court for reconsideration on this GPS.
Yes. May we hear that?
We can hear that, but what I can tell you is I've read the facts of this. You should probably still be on GPS. It's really for your benefit
Okay.
as well, because then people will know exactly what you're doing.
Yes, ma'am.
He has done, as this court probably has been informed,
Mhm.
a superlative job.
Yeah.
And I even have a letter today from probation for you to tell you how well he's doing.
All right, awesome. Just keep up the good work
Yes, ma'am.
and stay on tracking.
Yes,
That's
ma'am.
okay.
Thank you, Your Honor.
All right, you're welcome.
Take care.
All right, thank you.
Morning, afternoon, Your Honor.
Afternoon. So here's the thing. Don't send a message to the court with profanity in it. Number one, your case is set on the day it's set.
Mhm.
The person who you need to perhaps send that to is the person who is not here.
Correct.
Do you unfold your arms? So don't do that. One, you need to speak to your attorney and your attorney needs to be here. This case has been set numerous times waiting for your attorney. So the fact that you have what you put in your letter, I have bills to pay. I'm not a scrub.
Correct.
I have my own house and car now and have to pay the bills.
That's correct.
That's who you need. You need to be sending that to your attorney.
Which
not
I
the
have,
court.
which I have.
And there's nothing I can do with that.
And then you sending me here every day,
Mhm.
every day.
Yeah.
How am I gonna pay bills?
Yeah.
You say this is
You
a
need
place
to-
of communication.
Well, here's the communication. You need to talk to your attorney because guess what? The court schedule doesn't revolve around your attorney. It doesn't revolve around you.
And not
This
to be rude
case-
or anything, but
here's the
he
thing.
doesn't revolve around you.
This
Either
case-
he has stuff to do, he has
Okay.
federal inmates out of
Yeah.
county.
All
I
right,
can't
so-
make him. I tried.
All
I
right,
tried.
so this is what we're gonna do. Oh, we're gonna wait for his attorney. Okay, thank you. All right, court is calling 2024 CR 4260 and 2022 CR 4259W, State of Texas versus Renee Angel Cantu. Can I have parties announced for the record for the state
Daniel Escobar from the state of Texas.
defense?
Roy Barrera, Jr.
All right, and are you Mr. Cantu?
Good morning, Your Honor. Yes, ma'am.
All right, you entered a plea on April 2nd of no contest in each of these cases. The court found there was sufficient evidence to find you guilty in each of the cause numbers. Have both parties had a chance to review the PSI report, state
Yes, Judge.
defense?
Your Honor, this is the same PSI
Yes.
that was prepared for you when you first placed him on probation. So yes, we have.
No, I haven't placed him on probation.
Yes, Your Honor, he's on probation. And you gave him probation with all of these cases pending.
Just one moment. Could I see another file on Mr. Cantu?
And Judge, yes, that is correct.
All right.
Yeah.
I only have two files before me. That's why.
I have the PSI if you'd like to see.
Oh, no. I'm wondering if you all have any objections to the PSI.
No, it's the same PSI that we've seen before.
All right.
6-year probation. We applied for 5, so she gives us 6.
All right, thank you. All right, and each of the cause numbers, according to the plea bargain agreement, the state is opposed to your application. And it states in here that this is running concurrent with CM 105821.
And I think, Judge, that's one of the two cases, I think back when this pled, that waiver number may not have existed. So
Yes.
They just use the CM instead.
All right. And they're taking in consideration CM 104043, NIMAG number 712122 and 712121. All right, state, you are opposed?
Yes, Judge.
All right, any witnesses from either side?
Just my client, Judge.
All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, Your Honor.
All right, you can lower your hand, state your name for the record.
Rene Cantu?
All right, defense, you
Good
may
morning.
proceed with direct examination.
Thank you, Judge. Good morning, Mr. Cantu. How old are you, sir?
I am 33 years old.
Okay. And are you currently on probation in this court?
Yes, I am.
All right, and what are you on probation for?
I am on probation for a possession of manufactured delivered 4 to 200 grams that happened, I believe, in 2021.
Okay. Now, when you applied for probation in that case, which the court just ordered up, all of the matters that you've taken care of with Mr. Neil Cordero, they were all pending and included in the PSI that the court placed you on probation for. Is that correct?
Yes, sir, that's correct.
Okay.
All in 2021.
But since that time, most of those cases, the majority of those cases have been disposed of, either taking them into consideration or just outright dismissed.
Correct.
And now you're before the court on two of the cases that were pending before we even applied for probation in the case that you're on probation
Oh,
for.
yes.
Is that correct?
Yes, sir, that's correct.
Now, is it true and correct that since the court has placed you on probation, no violations of your probation have ever been filed or have occurred?
That's correct, not one. And I've been on this monitor for 3 years and since
All right,
and
so-
all good.
You're on a monitor for 3 years, no violations of the monitor.
Correct.
You've been drug tested for 3 years and no violations of any drug testing.
At
You've
all.
been, suffice it to say, 100% clean
Correct.
and in 100% compliance and in obedience with the court's probation.
Correct. And I don't know if the court remembers, but they gave me like a list of 9 things to do.
Correct.
Like intensive outpatient treatment, 12 weeks, a 90-day program, like just 9 separate things, but I've completed all of them. So yeah,
All right. And are you gainfully employed?
yes, sir, I am.
Are you full-time employed?
I sure am.
And so suffice it to say that on page 2 of this PSI, the court was informed of this myriad of cases that occurred prior to you being placed on probation.
Oh, yes.
Okay.
Yeah, they knew that before, since 2021.
And obviously, these cases are now disposed of, except for 2 that are before the court today.
Correct, yes, sir.
Okay. So have any negative consequences occurred in your life since the court placed you on probation?
Not with
The court.
the court, but with myself, of course, I'm like, so when I wrote the court a few times ago, I really didn't mean disrespect when I said, I'm not one of these hoodlum thumbs or thugs. I really did mean that. Like, I used to
Be a
mess up.
hoodlum.
Yes.
You used to be a hoodlum thug.
Yes,
That's
ma'am.
what you're saying.
So, like, I didn't mean it in a bad way, no offense, but I thought I was Billy Badass, excuse my language, but obviously that wasn't for me. So that's why I have done everything good now, because that life was stupid.
Okay,
like-
so here's the thing. This is the point that the court wants everybody to get to. Number one, when he was placed on probation in this court for that drug case,
Mhm.
the state was silent to his application.
Mhm.
When I accepted that plea, I was not given any of the facts of this because these were unindicted cases.
Correct.
So I would like for us to get to the point as to the drug dealing,
Mhm.
because when the stipulations that were entered into, that everybody agreed, these are the steps. He's selling drugs. and he's selling, and he's moving a large quantity of drugs. That's why this is over, I think, 200 grams. And the case that he's on probation for is not. The case that he's on probation for is, I think, 4,200.
Correct.
And these are over 200 grams.
Judge, when the offense that he's on probation for occurred, he was involved in drugs, clearly. They're all stated on page 2 of the old PSI. And Your Honor, all of that is history. And it is obviously known to this court by virtue of the fact that since you have been in control of his life, placed him on a monitor 3 years ago, he has respected all the rules and regulations of the law and of this court. And so we cannot deny his history. It is there before you. It was for you clearly when you respectfully granted him his probation. Judge, he has made a 100% turnaround from the life that he was living. That is not who he is today. And he has 3 years of sobriety to show for his really a miraculous turnaround. Can I finish?
Yes, sir.
Thank you. So we respectfully submit that he has proven to this court in every way that he is sober, he is gainfully employed, he is making an honest living for maybe the first time, and all due to this court's surveillance and this court's observations and this court's control. There is no reason to believe that he cannot successfully complete any term of probation that you would consider placing him on. To incarcerate him after he's made such a significant change in his life, Judge. I mean, this is a success case. We don't have a lot of them in this world of ours, but he has proven himself in every single way imaginable to this court. So the purpose of the state being opposed to his probation, well, clearly, historically, I respect their position. But to oppose probation today, after the man has lived a law-abiding life, a peaceful life, and a hardworking, diligent life as far as being lawfully, gainfully employed, to throw all of that in the toilet and incarcerate him would serve what purpose? I mean, clearly punishment is punishment, but probably God is the only person who knows how much he has punished himself over his young years. You know where his father is. His father's in the penitentiary for dealing drugs. You know from the last hearing, when we asked you for probation, this man is grown up in CPS world, going from home to home to home to home. Not a mom, not a dad.
Okay, I understand your
Yeah,
arguments,
yeah.
but do you have any more questions for him?
Yes. Do you believe that going to the penitentiary after you've changed your life would benefit you?
Not at all.
Do you believe that it would benefit anybody in this courtroom or anybody in the community because after 3 years of sobriety, now you're locked up? Would that help society?
No, that would be kind of dumb.
Okay, well, are you a contributing member to this community today?
Oh, yes. For the past 3 years, yes. Now I pay tax. I do everything legally now.
Oh.
Kind of side note. So yes, I just want you to hear for my own mouth.
That's fine, there's no question.
All right, so I tell you what, counsel, if you finish your
Yeah.
questions, then I'll allow state
Thank
to
you, Judge.
do cross-examination, and then if
Okay.
there's
The witness,
anything
Judge.
you wish to address with the court, you can. State, it's your cross.
Judge, sir, just looking very quickly at this PSI, well, one, did you review it with your attorney?
Yes,
Were you aware that during one portion it says the defendant denied suffering any abuse as a child and reported CPS was not involved in his childhood?
no, I was in CPS for from 9 to about 17 years old.
So why would it be in the PSI that your attorney didn't object to that CPS wasn't involved? And this is all stuff that they're getting directly from you.
I was in Child Protective Services from St. PJ's, from St. Jude's, yeah, like I could name them, Low Ridge.
Okay. So just going back, also looking at your criminal history, you agree with me, you have quite an extensive criminal history.
Yes, sir, I do agree with you.
And being out of Denver, it would be a assault to drugging victim where you did get probation. You were given 4 years probation, and that probation was revoked.
That was like a lesser charge. It was a regular fight, except to like a plea. Like the plea that I had, it
Right,
had
but
to
you
be
agree
something
that
about drugging.
You have that in your.
Oh, yes, when I was 19 years old, I'm 33 now. I was a teenager.
And again, it was revoked on that back in 2020, correct? It says
Mm,
right here in the PSI. granted
The case
removal.
happened in December 21st, 2014, I believe.
One of
It happened when I was 19 years old.
One other thing I wanted to ask or get into really quickly was what's changed? What exactly has changed?
I grew up. I'm not kidding anymore. I was hurt. I was angry. And I know I can't blame anybody for my childhood. Like he's like, yeah, your mom's dead, your dad's, who cares? Like I'm an adult now. Get over it. You have stuff to do. You have to be an adult, you have a job, you have everything. Be a man,
At the time of this offense, the offense that you're here before the court on, who was living with you at that home?
I was actually hopping around at that time.
Okay.
So I did need money. So I was trying any little way, to get money at that when that happened.
And again, this is after you've already been arrested for other cases and already had issues with drugs in the past. Is that correct?
No, I've never had a drug issue at all in my lifetime until these drug cases. Never in my life. So once again, that drugging victim is a regular fight out of Denver, Colorado when I was 19, except the plea had to be assault with drugging victim, but there was like no drugs involved at all. That was just like part of the plea.
Nothing further from the state judge.
All right, any other questions?
That's all, Judge.
All right, I have a question.
Yes, Judge.
So everybody, when they come before me, they're always talking about me, 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 me. My question is, what do you think was happening with the drugs you were selling?
What happened? Say it again. I'm
What
sorry.
do you think was happening with the drugs you were selling? What do you think they were going?
Hurting lives.
Mhm. And you continued.
Yes. Yes, ma'am.
And why were you selling drugs?
Because I needed money and I believe I had a job working at a warehouse. And I went from making like $6,000 a week to maybe $300-400. So that was not, I was so used to like living with $3,000 or $4,000 for my rent, for everything. So I started like panicking, like, oh, dude, I need money, So that's when I thought I was Billy Badass, and I wasn't.
Oh, yeah. So walk me through this. So you are working.
Yes, ma'am.
So how do you reach out to somebody saying, hey, I want to sell some drugs for you?
So I was kind of in the ghetto, the West Side, and it's not hard at all. Like you literally just go right there on Guadalupe. Hey, dude, what do you want? You have everything there. So, of course, I initiated. I'm like, hey, I need some money. Like, what can I do? And then, yeah, that's how it. Well, okay, you want to work? Well, here we go. And literally, like the second time, that's when the officers like, oh yeah, by the way, I'm an officer. Like shit.
Okay. All right, any other questions?
No.
Any other witnesses?
No, Your Honor.
All right, court will hear argument.
Judge, the state's gonna argue here that I think he should at least get the 10-year minimum. These are a lot of drug cases that are all coming in very rapid succession. He also has a very extensive criminal history. The state asked what's changed between now and then. And there really wasn't an answer that was given. There was no details as to what he's done, other than being on under court supervision, where he knows if he tests positive for drugs, that's something that can get him in trouble. If he does anything out of line or commits another offense, that's something that's just going to make it worse for him. So again, it's something that we haven't really had any detail as to what exactly has changed. So the state would ask for 10 years in the prison.
All right,
Judge, his entire criminal history was known to the state when this court placed him on probation. Nothing negative has occurred. Everything positive has occurred. This is a successful probationer. This is someone who has changed his life around. I don't understand the logic. What has changed? This man has changed. The man before you, Exhibit A, has changed. His entire criminal history is spelled out very clearly when the same state of Texas recommended probation.
oh, I
Or
think
at
they were
least-
silent.
or remain silent. And no objection at that time was offered by the state when this court granted him probation. Judge, this court, has helped him, as he said in here. Why do you want to be on probation? And he said, because it'll be my mentor. And you, whether you have agreed to or not, have been his mentor. You, whether you knew it or not, have had a very positive impact on this man's life. And Judge, I can't underestimate the strength of the statement. He has not stepped across the legal line in 3 years. How can we punish him today for what happened when he was 19 or 20 or 21 or whatever? And
I
these
think this is
cases,
from 2022.
these cases were already pending when the court considered everything and placed him on probation. He has not disappointed you. He has not disappointed probation. He has not disappointed anyone. His employer loves him. He is a hard-working, sober, contributing member of this community. To throw his life away and give him 10 years in prison, Judge, I don't see what good would come out of that, because he has demonstrated that he not only can talk the talk before you today, he's walked it. Every step, Judge, he's walked with you, with your probation office. I mean, thank you. He's not who he was because of this court. And now, at the last minute, to pull the rug out from under him and say that we need now to protect society from what you did back before I gave you probation, I don't see the logic in that. What purpose would be served to incarcerate a middle-aged man who admitted that he was a young, want to be the person who did not respect the
I mean,
law.
he wasn't young. because this is in 2022, so it's 2 years ago. He tells me he's in his 30s.
Correct.
So doing young and dumb things is usually teenagers, not people who are in their late 20s. I mean, that,
Yes, I understand.
for the
that.
court, that argument, I'm young and I'm dumb and I'm in my late 20s and I can't control my impulses, that's usually for teenagers.
Sure. And that statement was going to all of that history that was brought up by the state, you know, in Denver, Colorado, and here and there and everywhere. That's where that statement was going. Judge, he admitted his guilt. He came before this court. These cases have been pending a long time, and he has never absconded from the jurisdiction of this court. He's never missed a court date or a court hearing. And, you know, he has patiently waited for this day to arrive, and it has. And I just would ask the court to consider the good that this court has done in this man's life, and why, you know, throw the baby out with the bathwater at this time, Judge. It's you know, 10 years of probation. He's done so far so good. You can still give him the 10 years the state wants you to give him today. You can give it to him tomorrow, next week, next month, or next year.
All right, thank you. Anything else from the state?
Judge, again, these few cases that you have before you, you didn't have this information whenever you decided to give them probation the last time. It's because they were still pending. They hadn't been indicted yet. There was no movement on them. Now that they have come forward, this is what we offered based off of the facts that are in these cases. Again, the court did not have these before. You have them now. You have the ability to take this into consideration. This isn't a teenager who's making bad decisions. This is a grown adult. It's a grown man. He made these choices and the consequences that both know.
All right, thank you. All right, so Deputy Mejia, Deputy Laura, if you'll take him into custody and counsel, you need to be back here at 11 and the court will make its decision.
Thank you, Judge.
All right.
I'm on the video conferencing with the State Board of Pardons and Parole.
All right, so we're back on the record in 2024 CR 4259W and 2024 CR 4260W. State of Texas versus Renee Angel Cantu. Can I have parties re-announced for the record for the state,
Jason Garrett, Your Honor.
for the defense?
Roy Barrera Jr.
And you're Mr. Cantu?
Yes, ma'am, Your Honor.
Why are you banging on the walls in the back?
My ankle monitor was going off 5 separate times. Officer Mejia heard me or heard it. I was like putting it on the door. Just so I didn't want to get in trouble. It would be my very first violation in like 3 years. But Miss Priscilla Valadez is my officer. If you could please tell her.
No, that's not what we heard in the back.
Yeah,
That it wasn't related to your GPS. It was you bamming on walls.
No, it was me shaking the door to get his attention. But yeah, I think my thing's dead now and I don't want to get in trouble.
Mm-hmm. Is there anything else?
Your Honor, he has probably never focused on doing what is right for as long a period as time as you've had him on probation as well as on your conditions of bond. It's amazing.
Look, it's good enough right now.
Yes.
It just started to get.
Okay, it's amazing the turnaround that he has done. It's working full time, out of the I guess the situation, the friends that he was keeping, all of that, Judge. But he'll be the first to tell you it was you and this court, and it was your probation officers who have guided him and mentored him and advised him and counseled him, all the way through. So I don't know that he could have done any of this without being under, your watchful eye and that of probation. You generally have some kind of excuses about ankle monitors, and typically, at least in 3 years, you'd think that you have some, even though it was just an accident, some violation, however minuscule, but gosh, I don't know how more perfect that you could get than perfect as far as his behavior and his record. And in view of the fact that, as you can see, he looks perfectly healthy. This is a life of no alcohol and no drugs, and just really getting a grip on the fact that he knows what prison's all about, Judge. He's been there. He knows what jail's all about. He's been in many. And he knows what his father's gone through, and he's still there. So I think he's really just made a world of improvement over his personal life. And because of all that you've done, professionally speaking, all the people he could blame, all the excuses he could have, he's got them if he wanted to use them. And you've never, ever heard him tell you anything about his past. His past is very checkered, no question. But also, the hand that he was dealt was not straight aces. He's made the best with deuces, and he's climbing out of a deep hole, Judge. And he wants to continue to climb that ladder all the way out and stay out. So I would hope that you would consider all the good that he's been able to accomplish and allow him the opportunity to continue doing what's right, what's good, what's healthy. You can just look at him. He's living a healthy life. Well, it's true.
Yes.
All right, anything from the state? All right, so here's the thing. Mr. Garahan, I know you're not the one who worked out this agreement. And this is why the court likes for cases to move quickly enough so that everybody, no violation of due process will occur. Because many a times I will have people who come before me and cases have been transferred from other courts where somebody's on their 4th or 5th DWI. And they come to me and it's been transferred to my court. And this person has been on ignition interlock for 4 years because I end up with an old case that's been transferred from another court. And then what ends up happening is people will argue to me, this person has been in rehab for 2 years. Everything is going well for them. Isn't punishment about rehabilitation? And that's true. Punishment is about rehabilitation, but it's also about punishment. He was placed on probation by this court in another case, 2022 CR 11790. And he was placed on probation in that case because parties proceeded on it as a possession case. Let me check to make sure. Yes, parties proceeded on it as a possession case, and the state was silent. And while these other 2 cases were pending, that's when the plea was entered into. The court did not receive information about these 2 cases because I'm assuming, and anybody can correct me if I'm wrong, labs were not in, so no one knew what the drugs were would be positive for. And no information was presented to the court in the sentencing for the 2022 CR 11790 case, the weight of these drugs, what these drugs were for, because Again, nobody had information on that. And the laboratory reports were not in. So hopefully more money will be spent in improving how long it takes for drug testing to come back. So we won't have a situation that we have now. So now what I have before me is I have a situation where somebody is on probation. The court hasn't received any violations of probation because these cases were pending when he was placed on probation. So technically that is not a violation. And in these two cases, you're a drug dealer. That's it. And you are building your happiness off somebody else's misery because drugs destroy lives and people who are drug dealers are doing it for a quick buck.
Correction, Your Honor, I do not
No,
do that
do not
anymore.
interrupt me.
Yes, ma'am.
You were dealing drugs.
Yes, I was.
You were building your happiness of somebody else's misery. There are people who are out there for whatever reason, maybe they're young, they don't know any better, and they start taking drugs, and the next thing you know, they can't kick them.
Yes, ma'am.
Then you have some people who are in their 30s, they start using drugs, and then they can't kick them.
Yes, ma'am.
But this is destroying people's lives, and this was drug dealing.
Yes, ma'am.
Why the federal government has not come to your doorstep, I don't know. This is state jurisdiction, so I'm just dealing with what I have before me here. Under normal circumstances, all things considered, if you just had these two cases and you're not on probation with the court, I'd send you to prison. But you're on probation. And so I have to deal with what I have here.
Yes, ma'am.
So this is what the court is going to do. In each case, the court is finding you guilty. The court is sentencing you to 10 years in the prison. That will be suspended and probated for 10 years. These cases will run concurrently. Taking consideration CM 104043, NITMAG number 712122 and 712121. You're going to remain on GPS until further notice.
Yes, ma'am.
So that's GPS until further notice. Probation. I'm going to want random field visits. Until further notice. And there's to be field visits no less than 2 months. No less than every 2 months. I'm going to order the MRT.
I didn't hear that.
MRT,
What is that, Judge?
moral recognition therapy.
Okay.
There's to be regular reporting by Zoom or in person. The UA hotline until further notice. And probation, the UA hotline, he needs to be tested at least once a month and it's random. But if y'all want to test him more than that, you can test him more than that. There's to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. And based upon what you said your occupation is, they need to know what you're on probation for. And they need to provide a letter to probation stating that you've informed them what you're on probation for. Do you understand?
Yes, ma'am. It's already in file. I was 10 steps ahead. I already had it from my boss.
Yeah. All right. You need to turn it over to probation.
Yes, ma'am.
And probation, you need to call his employer to make sure that that's the employer. There's going to be 200 hours of community service restitution. Probation, is there anything else? And state, do you know if there's any restitution I'm going to put restitution for drug testing. All right, and there's going to be restitution for drug testing and each cost.
Which
I think the DEA are the ones who did that. Let me double check. I think it would be the United States government, and we'll see who wants it as far as the funds.
I believe it was the state, Judge. I
I'd have to check.
All right, let me check. It says Dallas. All right, and probation, is there anything else?
No,
Anything else? All right, and also you're not, just 1 second, and also you're not allowed to possess any scales. So you're gonna have to figure out how else to weigh yourself.
Yes, ma'am.
Probation? Yes, counsel?
Yes, Judge, are the three probations running concurrently?
Yes.
Okay.
Is there anything else?
Thank you, Judge.
Hey, what do you suggest on my ankle monitor? Just call Miss Priscilla Valadez and say, hey,
Probation will tell you what to do with that.
thank you very much, Your Honor.
All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am, I should.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with your attorney. Do you understand?
Yes, ma'am.
Right, probation.
Yes, Judge, in regards to the monitor, is on the monitor through withdrawal services. So,
All right,
let that monitor removed or have the new monitor installed before removal or?
yes. I need to have a new monitor installed before removal.
Is that going to work release or what happens to that monitor?
All right, if it's through work release, will he have to walk over to the jail? All right, they've been saying they don't want that anymore because they are low on funds. You're gonna have to pay for GPS.
Okay, it's $300 a month. I remember you have waived that.
That's because you're with pretrial. But this
Okay.
is an outside agency, so I can ask that it be waived,
Okay,
but I have no authority.
so last December, I believe, I came to you, I'm like, you placed me on probation and said, hey, if you.
Okay, let me just stop you right there. So here's the thing, and we're off the record.
Yes, ma'am.
You were 2 seconds from going to prison. And when people are 2 seconds from going to prison, you know what they end up telling me? And I tell you, your attorney can tell you this too. And because I'm sure he's had clients do it to him. You know what? I will do a lifetime probation. And then when you get the probation, then you start asking for extra. So you need to hold on to the thought
Yes,
that you were 2 seconds from going to prison for 10 years.
Yes, ma'am.
All
I
right.
apologize. Yes, ma'am.
And now you're on probation.
Yes, ma'am.
So you need to let that marinate.
Yes, ma'am.
Okay.
Yes, ma'am.
All right.
I like that word.
right.
Marinate.
Yes. All right. Thank you.
Hey, thank you, Your Honor.
You're welcome.
Let's get the facts straight. She loves a verbal ashtray. Never blowing smoke when she gets pissed. She's quick to castrate. Love her on a good day, love her on a bad day. Either way, she's here to stay, stay, stay.